Welcome, Liz. Give us a brief orientation to estate taxes and who should be thinking about the implications of estate taxes.
Thanks so much, Susan. And the laws around estate taxes have really changed a lot in the past few years. At the end of 2017, the Tax Cuts and Jobs Act that Pam had mentioned, it doubled the estate tax exemption amount. So that means that each individual can transfer either through lifetime gifts or bequests up to $11.58 million to their chosen individual beneficiaries without paying a cent of estate tax. And for a married couple, they can combine that to over $23 million. And so that means that really most of the conversations I'm having with clients these days really are not as much focused on estate taxes and really more focused on really the goals and priorities of the family. Of course, these laws could change. Currently, the estate tax exemption amount is set to sunset at the end of 2025, at which point the exemption would probably go down to around $6 or $7 million, depending on inflation. But Congress could act sooner and really change the law at any time, so we don't know what those changes will look like until they actually happen. So for families where estate tax is a concern, there's lots of things that we can do to help reduce the amount that you have to pay. And one of the most common ways to do this for people who are charitably inclined is to make a bequest to charity. And this is really because you don't have to pay estate taxes on gifts to charity when you pass away. But even for families where estate tax is not a concern, I still think it's really important to think about charitable giving as part of the estate plan. And I asked nearly every client of mine if they want to include a charity as part of their plan. And while certainly not everyone does, I think it's really an important thing to bring up, even for those families where estate taxes is not our primary concern.
Great. Talk about some of the strategies that you use with your clients in estate plans, and you might talk a little bit as part of that as charitable split interest trusts as well.
Sure. So, one way, of course, is just to make an outright bequest to charity. This could be done in your will or in your living trust. Another thing that you can do is, make a charity a beneficiary of maybe a life insurance policy or retirement plans. And actually, retirement beneficiaries can be a really good way to make a gift to charity. I actually had some clients come in a few weeks ago who told me they wanted to make a pretty significant bequest to their alma mater. They're both Longhorns. And I noticed that the wife had a pretty sizable IRA. So I recommended that they make the gift to charity from that retirement account. And I explained that's because the retirement plan proceeds are actually worth more to the University of Texas than they would be to their children. And that's because the retirement plan assets will eventually be taxed to the beneficiary. They're going to have to pay the income tax on it. If the beneficiary is an individual, it's taxed as ordinary income. But if the beneficiary is a charity, the charity is tax exempt and therefore really does not lose any part of that inherited benefits to income tax. Some other ways that people might make a bequest to charity, sometimes people have a donor advised fund and you can actually make a bequest to a donor advised fund. Some families have already set up a private foundation, or maybe they want to set up a private foundation as part of their estate plan. So that sometimes we'll do that. And then another way is through what's called a split interest charitable trust, which you were asking about, Susan. And a split interest charitable trust really allows you to pass wealth to your heirs in a really tax efficient way, while also supporting charity. And the gift to charity either could be now or down the road. And they are called split interest charitable trusts because the financial interest from the trust is split between a charity and a non-charity, like your children.
Thank you so much.
Sure.
So you can create those during your lifetime. And so, again, you talked about the split interest trust as being something where you can give your assets to both the charitable interest as well as your children. So you kind of get a both and, but can you elaborate on, some other reasons or what some of your clients say about why that's important to them?
Yeah, sure. And there are, ways to do these split interest charitable gifts as a beneficiary of your estate as well as lifetime. And there's sort of two general types of the split interest trust. There's what's called a charitable lead trust and then what's called a charitable remainder trust. And they're basically inverses of each other. The charitable lead trust makes a gift to charity for a number of years, and then it is paid out to your chosen beneficiaries at the end of the term, whereas a charitable remainder trust makes sort of annual distributions to your chosen beneficiaries, and then at the end of the term, the remainder is distributed to charity. And one of the times I'm really talking about charitable trusts with my clients right now are for clients that have really large retirement accounts. And this is because of another recently passed law. It's called the Secure Act, and it became the law at the end of 2019. And it really changed how beneficiaries are taxed on inherited retirement accounts. So when a qualified retirement account passes to the individual beneficiaries, the beneficiary still has to pay the income tax on distributions from those accounts. Before January 1st, 2020, the beneficiaries could stretch out the required minimum distributions, the RMDs, over their life expectancy. So if you left your retirement account to a grandchild, they could have 50 years to stretch out those required minimum distributions. And that meant that each of those was relatively small and also made it more tax efficient because it's less likely to bump the beneficiary up into a higher income tax bracket. Under the Secure Act, now most beneficiaries have to withdraw the entire amount within 10 years of the owner's death. So this accelerates the income tax, increases the amount that's going outright to that beneficiary, which might not be what sometimes people want for their children or grandchildren. And it's also likely to increase the amount of tax due, since it will likely bump the beneficiary into a higher income tax bracket. So an alternative to this is a charitable remainder trust. The trust can provide the beneficiary receives a payment of, say, 5% of the trust value every year for the rest of their life. And then at the end, after the beneficiary passes away, any remainder can go to charity. And so this can be a really good technique to use for clients who, my clients who want to benefit charity and are also concerned about their beneficiaries receiving a large amount of money all at once and what the income tax consequences of that are.